Attorneys for accused Idaho College murderer Brian Kohberger are asking the judge to throw out his indictment. The defense claims the grand jury in the case was misled in their instructions. The issue involves the standard of proof the jurors used to make their decision. 4 students were stabbed to death in their off-campus apartment at the University of Idaho in November of last year. Kohberger was charged with the murders and has entered a not guilty plea. NewsNation's Brian Enton's been covering this story from the start, and he joins us live. And former homicide prosecutor Matt Murphy joins me on set. Brian, let me start with you. What was the grand jury told, and why do defense lawyers argue it was wrong?
Well, you remember, Elizabeth, that the defense was fighting for a while to get the transcript from the grand jury proceedings. Now, this may be the reason why. This was like a 25-page filing that dropped late yesterday. Essentially, they are saying that they want the indictment dismissed, alleging that the jurors were misled as to the standard of proof required for an indictment. They say that they should have been told beyond a reasonable doubt. Those should have been the instructions to the grand jury, but instead they were given a lower standard of proof, which the defense claims violates the Idaho state constitution, and they are saying that the whole thing should now be thrown out.
Matt, I thought beyond a reasonable doubt was what you got in a criminal trial, in the actual trial. The whole saying is you can get indicted, a grand jury would indict a ham sandwich, because what is the standard?
Well, okay, so they cited an 1887 statute for this, and when you're actually doing these kinds of cases, that's usually a pretty good sign. So what the defense is doing is they're going through the motions, literally, where they are preserving these issues on appeal. And there's vague language from the incorporation of Idaho as a state, that's how far back they're going, indicating that one of the possible interpretations was you had to present proof beyond a reasonable doubt to a grand jury. The Idaho Supreme Court has since ruled on this, I believe more than once, saying no, like every other state, an indictment requires proof basically to a preponderance or probable cause. So what's going to happen here, the court's going to read it, consider it, the record will have been made, and then the court's going to deny it.
Well, anywhere is a grand jury told you have to find somebody guilty beyond a reasonable doubt?
No. And the constitutional right...
Because the defense isn't even putting on its case, in a grand jury proceeding.
You have a constitutional right, essentially, to have either a preliminary hearing to determine probable cause. That's essentially evidence is presented to a judge who sits there and makes the ruling. Or you can go to a grand jury. There are advantages and disadvantages to that. But the standard is the same. Is there probable cause to believe that a crime has been committed and that this defendant committed the crime? That's it. So 1887 statute, it's a very creative legal argument. The defense is doing what they have to do to preserve these for the appellate process, but it's going nowhere.
Brian, I'm curious, have we gotten any reaction from prosecutors or from the victims' families to this latest legal maneuver?
No, this just came down yesterday. Again, I think it was a bit of a surprise. People didn't expect it. I'm told, I talked to a couple of lawyers in Idaho, that it's unprecedented, that no one has ever filed a motion quite like this to dismiss an indictment for these reasons. So it's going to be interesting to see what the judge says. It seems like, obviously, the defense wants a preliminary hearing. That would be to their benefit. They could question witnesses. That's what we thought was going to happen for a long time. We didn't realize that this secret grand jury process was happening behind the scenes. And it seems like they want this preliminary hearing to happen.
Finally, Matt, we learned this week that Brian Kohberger's attorney said in some legal filings that they plan to provide proof that he has an alibi at the time of the murders. They're not saying who that alibi is or any details about that at all, but that they're also planning to argue that police planted his DNA on the knife sheath that was left at the crime scene next to one of the victims' bodies.
Right. So that's 2 separate issues. Again, what the defense is doing, under Idaho law, they're required to present notice of a potential alibi. So they had to do that. They had to preserve that, to preserve the right to actually present that. They needed to do that.
Okay.
Regarding planting the DNA, that's a separate argument. That's kind of an eye roller, I think. But it's worked before. They're going through the motions. They're dotting the I's and crossing the T's, so to speak.
You called it the O.J. Simpson defense. maneuver.
Yes. So, I mean, look, if you take it to its next logical step, and I suspect these prosecutors are going to do exactly that, for a conspiracy like that of the police to have actually planted the DNA, if you look at it, given the time of night that this happened, it's not a very difficult logical step to say, well, that means the conspiracy existed before the murder. The only way you can know that a murder is going to happen is if you're going to commit it, which means they would have to argue the defense that the police actually murdered these college students. Nobody's buying that. So I think that if they run that in the trial itself, they run the risk of impacting their own credibility so badly that it could hurt them in the penalty phase. In this case, we'll get to a penalty phase.
Okay. Thanks so much for watching. Go to joinnn.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.